Thank you. Hello and good morning. My name is Marissa Streckfus. I am the claims manager for RT ProExec. I am based in Bloomfield, Connecticut. I would like to welcome everyone to this webinar brought to you by RT ProExec, the Management Liability Division of RT Specialty. RT ProExec is the nation's leading specialty insurance brokerage practice, focused exclusively on executive, professional, and transactional liability. RT ProExec is a division of RT Specialty, one of the largest, fastest growing insurance intermediaries in the country. In 2019, RT ProExec placed in excess of $1.4 billion in financial lines premiums, and RT placed more than $8 billion in premiums across all lines. In our webinar today, we are going to be discussing the key developments in the directors and officers liability arena during the past year. Things are always changing in the world of D&O liability and claims, but 2019 was particularly eventful. As we will be discussing this morning, last year's top developments have important implications for 2020 and beyond. We are fortunate to have with us this morning to discuss these issues my friend, colleague, and personal D&O guru, Kevin LaCroix. Kevin is an executive vice president of RT ProExec based in our Ohio office. Kevin has been involved with D&O liability issues for over 35 years. He is also the author of the widely read blog, the D&O Diary, which the New York Times called influential and the Wall Street Journal described as widely followed. Kevin will be discussing the top 10 developments in the world of directors and officers liability during 2019. And we want to let you guys know about a few preliminaries. Our audience members can ask questions using the Q&A text box located on your screen. And if we have time during the webinar, we will address those questions that you ask. If we are unable to get to any questions, you are able to contact Kevin or myself at any time. We are interested in your thoughts about today's webinar, so we would be very grateful if after this session you could drop one or both of us a note to let us know your thoughts about today's session. Our final slide this morning will have our email addresses, so please feel free to contact us with your questions and comments there. With that, I am now going to turn it over to Kevin to lead our discussion. Kevin, please take it away.
We are going to focus on the U.S. federal securities class action litigation first. And if you can have the first slide, Chrissy, thank you. Because securities litigation is the most significant severity risk for U.S. publicly traded companies. One data point that the industry observers watch is the number of securities class action lawsuits that are filed annually. And in particular, observers will want to see some version of this slide. Chrissy, the next slide, please. This slide shows in a bar graph form the number of securities class action lawsuits filed in federal court annually in the United States. As you can see, in 2019, there were 404 securities class action lawsuits filed, slightly more than the 402 in 2018, and just a little bit less than the 412 filed in 2017. I'm sure that every observer will note that for the last 3 years, there were significantly more than in prior years, and that for the last 3 years in a row, we've had more than 400 securities class action lawsuits, which is a truly extraordinary development, nearly double the annual average number of filings for the period of 1997 through 2017 of 203. What you have is extraordinary numbers of filings each year, which kind of begs the question, why was there that significant jump in 2017? And one obvious reason is the shift of merger objection lawsuits from state court. Slide, please, Chrissy. In this lawsuit, the orange parts of the bars are the numbers of merger objection lawsuits filed in federal court, and the blue parts of the bars are core securities class action lawsuits or traditional securities class action lawsuits. You can see that there have always been merger objection lawsuits, but the number jumped significantly starting in 2016 and then increasing in 2017, 2018, and 2019. And the reason for the change was a hostility that emerged in the Delaware courts to these types of merger objection lawsuits. And rather than pursue these types of lawsuits in state court, particularly Delaware court, the plaintiffs' lawyers are filing these now in federal court. It's easy to think that all of the run-up in the last 3 years in the securities litigation is the result of this phenomenon of merger objection suits being filed in federal court. But if you look at the blue parts of the bar, you can see that the 246 traditional or core lawsuits filed in 2019 was the highest number during the time period reflected in the slide, and significantly greater than the early parts of the period. In fact, it's about 21% above the 1996 to 2017 annual average of 203. So even though a significant part of that increase in the number of securities class action lawsuits is attributable to the merger objection lawsuits, there still is significant increases in the traditional lawsuits as well. Looking at the number of lawsuits is an interesting way to consider what's going on in securities litigation, but an even more meaningful way to look at the filings is to think of them in terms of the rate of litigation, that is the number of lawsuit filings relative to the number of listed companies. And if you flip to the next slide, Chrissy, we can look at the litigation rate. These bars show that the rate of litigation, first of all, is at its highest level in 2019. The 8.66 means that roughly 1 out of every 11 U.S. listed companies was hit with a securities lawsuit in 2019. And if you look at the rate of litigation, you can see that it really started trending up all the way back in 2009 and has progressed steadily since that time period. But again, these figures showing the rate of litigation are affected by that mass of merger objection litigation coming in the last 3 years as the cases were shifted from state court to federal court. So a more meaningful way might be to look at the litigation rate of traditional litigation filings. And that's on the next slide, which shows here is the litigation rate for traditional federal court securities litigation. And if you look again, you can see that really steadily since the 2009, 2010 timeframe, the rate of litigation has increased steadily and really every year since 2012 to the point that the litigation rate is nearly double the annual average litigation rate of roughly 2.9%. And if a rate of 5.34% means that roughly 1 out of every 20 U.S. listed company faced a securities class action, a traditional securities class action lawsuit in 2019. When you're thinking about the significance of this litigation rate, it's important to keep in mind that these figures just relate to the federal court lawsuits. In a moment, I'll be talking about state court securities litigation, which, were it added to these figures, would show an even higher litigation rate. Another important way to think about this information when you consider that the litigation rate is nearly double the long-term average, and that it's been going up every year, it means that D&O insurance underwriters are facing a very different frequency environment for securities litigation than has been the case historically. And this represents a new normal that has not traditionally been priced into the premiums for D&O litigation risk. And this is one of the significant factors that's contributing to the disrupted D&O insurance marketplace that I'm going to be talking about at the end of the presentation. So what are your thoughts about this, Marissa, and what do you think about what these data show?
Sure. So Kevin, I wanted to talk about your first and second bar graphs in this particular section. So obviously we see in your first bar graph an overall increase and a dramatic upswing in the number of securities class action lawsuits that took place in 2017. And then in your next slide, which goes over the breakdown between merger objection suits versus traditional securities suits, we see that merger objection lawsuits are a part of that major increase that we saw in 2017. But even without merger lawsuits, the number of lawsuits is higher compared to historical levels of the rate of litigation. And it's that litigation is higher than it's ever been. So why do you think that's happening?
Yeah, it's a good question because more securities fraud lawsuits, I think everyone on this call understands that's not because there's more securities fraud. It's really because of changes in the way these cases are being litigated. And really, it's a result of shifts in the plaintiffs' bar in the United States. There are plaintiffs' firms who are much more active in the past. They've been referred to as emerging law firms, and they've clearly adopted a litigation model that favors filing more lawsuits, I guess on the theory that more inventory means more opportunities for revenue. Even though the dismissal rate has also gone up as the number of lawsuit filings has gone up. I don't have a slide that shows this, but the historical dismissal rate was in the 33%, 40% rate, and more recently it's gone up to the 40 to 50% rate. But I guess for the plaintiffs' lawyers who are filing these cases, it's still profitable to file as many lawsuits as you can in the hope that some of them will stick. Even if the cases are dismissed, that has consequences, obviously, for the defendants in those cases and for their insurers. The cases have to be defended, and it's expensive to get a case dismissed. So with the increased litigation has come increased costs, and that's clearly a significant factor in the changed D&O insurance marketplace. I think we can go to the second introductory slide. Thanks, Chrissy. I know that most of the people on the call are familiar with the U.S. Supreme Court case in Cyan, which on the next slide, as reflected on the next slide, Cyan was a 2018 decision by the United States Supreme Court, which affirmed that state courts retain concurrent jurisdiction for Section 11 claims, and that those Section 11 claims filed in state court cannot be removed to federal court. What this does, and the concern when the decision came down, was that this would lead to parallel state and federal actions and even to multi-state actions. This concern about Section 11 litigation is primarily of concern to IPO companies, but not exclusively. It could affect companies with secondary offerings or companies issuing securities in connection with M&A transactions. So if you turn to the next slide, Chrissy, the concern about the possibility of increased parallel or multiple litigation has in fact come to pass significantly in 2019. One thing about the bar graph that you're looking at now that's important to keep in mind that the bar for 2019 only goes through October 2019. It doesn't include the last 2 months of 2019. This data is drawn from research by Professor Michael Klausner of Stanford Law School and his colleagues at Stanford Securities Litigation Analytics. But you'll see that even just through the end of October, there were more state court securities class action lawsuits filed in 2019 than any other year. It dipped down slightly in 2017 while the Cyan case was pending. But you can see once the Cyan case came down in 2018, plaintiffs' lawyers started filing more state court securities class action lawsuits. Well, what about this issue of the parallel or overlapping litigation? The next slide shows further data by Professor Klausner and his colleagues. And this shows three pie charts, which show three different slices by time period of the state court securities class action litigation. The one on the left and the one in the middle are two slices of the pre-Cyan data, and then the one on the right is the experience post-Cyan. And you can see that in the older period, all the way on the left, 88% of the Section 11 cases were filed in federal court. And even as we came closer in time and there were more state court securities class action lawsuits filed, you still had 2/3 of the Section 11 lawsuits filed in federal court. But you can see that post-Cyan, the federal court only Section 11 lawsuits are now only about 1/3 of the lawsuits, with 2/3 of the Section 11 lawsuits being filed in state court. And fully 43% of those cases involve companies that are sued in both state and federal court. And it means that those companies face the problems that come from overlapping or parallel litigation. That's particularly a problem between state and federal because there are no mechanisms to consolidate or even to coordinate litigation between those jurisdictions. And there arguably is no application of the federal court discovery stay in state court, which leads to the possibility of inconsistent procedures in state and federal court, and certainly leads to the possibility of multiplying defense costs. Even if the state court cases are filed in the state court, but in different counties, for example, one lawsuit in San Mateo County and one lawsuit in San Francisco County, you can have problems with the coordination between these cases. These developments have led to a disrupted marketplace for IPO, and anyone on this call that's been involved in an IPO knows that the marketplace for D&O insurance for IPO companies is quite disrupted, and the premiums that IPO companies are paid has escalated significantly. The retentions that the insurers are requiring have increased significantly, and all of those trends accelerated as 2019 progressed, and I think have continued with force as we've headed into 2020. So, Marissa, what are your thoughts about that?
Sure, Kev. So you mentioned that the plaintiffs' lawyers are now filing state court cases against IPO companies, and it's very clear from the data sets we're using on these slides. Has the litigation frequency for IPO companies gone up? Are they more likely to be sued? Or is the only thing that we're seeing as a change that there is the possibility of dual forums in both the federal and state courts?
It's a great question, and I think it's easy when you look at the bar graph that was on the prior slide that showed the increasing number of state court lawsuits to jump to the conclusion that more IPOs, for example, are getting sued. I understand that there's additional research coming forth from Professor Klausner and his colleagues that will show that, in fact, the frequency for IPO companies has not gone up. So the risk here is not so much that more IPO companies are going to be sued. It's rather than if they're sued, they face this heightened prospect of multiplied litigation with all of the procedural complexity and increased costs that presents.
And most of your discussion about the impact of Cyan has involved IPO companies. So are IPO companies the only types of companies that are potentially affected by the Cyan ruling?
No, as I mentioned in an earlier slide, this is a risk for Section 11 litigation that can arise in connection with secondary offerings or follow-on offerings. And there have, in fact, been lawsuits filed under Section 11 against companies that had not completed IPOs, but that had completed follow-on offerings or secondary offerings, and even in connection with companies that are issuing additional securities in connection with merger transactions. And there has been a certain number of those cases filed, including one that settled in 2019. So this issue is of most importance to IPO companies, but it is not limited just to IPO companies. It also is potentially significant with respect to those other companies conducting a distribution of new shares into the securities marketplace. We can, one final point about this effect on IPOs. I just wanted to point out that my colleague John Reiner is going to be moderating a panel at the Plus D&O Symposium at the end of February on the topic of the current state of the D&O market for IPOs. So I know everyone will want to look forward to that. If we can turn to the first slide for the third section now. I know that everyone will recall that a significant part of the securities litigation, federal court securities litigation, was merger objection litigation, and the shift of that litigation from state court to federal court. In 2018, which is the year for which we have the most complete recent data, 83% of all completed deals over 100 million attracted at least one lawsuit, and of those lawsuits, 92% of the merger lawsuits were in federal court. Most of these lawsuits are being filed by a very small number of plaintiffs' law firms. And the next slide, please. The way these cases were settled traditionally through, I would say, 2018, is the plaintiffs' lawyers would agree to a disclosure-only settlement where there would be additional disclosures by the defendant company, and the defendants would pay the plaintiffs' attorney's fees, and the plaintiffs would give the defendants a comprehensive release. It was a court-supervised process. But in the Delaware courts and increasingly in the federal courts, there were questions about the value of this entire process to shareholders. So in order to avoid court scrutiny, plaintiffs' lawyers have adopted a new model where rather than going through a class settlement, they're voluntarily dismissing the lawsuits in agreement for the defendant's agreement to adopt additional disclosures in either the proxy statement or the tender offer document, and to pay the plaintiffs a so-called mootness fee because the case has become moot. This is a practice that academics studying this sequence of events have called a shakedown with little benefit beyond lining the plaintiff's attorney's pockets, and it amounts to blackmail as the defendants pay the fees just to make the cases go away. If you shift to the next slide, please. There has been judicial skepticism about this entire process, most notably in the Northern District of Illinois in the Acorn case, where Judge Durkin abrogated a mootness fee arrangement, ordered the plaintiff's fees to return the over $300,000 fee because the additional disclosures Judge Durkin found were worthless to shareholders and the case should have been dismissed out of hand. Very strong words. The case is on appeal. As you might expect, the plaintiff's lawyers strongly dispute Judge Durkin's characterization. Stay tuned. But clearly it's heartening to those of us who worry about the impact of these kind of lawsuits on our economic activity and merger transactions. There also was a case in the District of Delaware where Judge Andrews rejected a plaintiff's fee petition because the plaintiffs had failed to establish that the disclosures established a substantial benefit. We can all hope that the courts become more skeptical of these mootness fee arrangements and that act in some policing role to try and discourage these kind of lawsuits, because these really do represent attacks on legitimate economic activity in our corporate and security system. What are your thoughts, Marissa?
Kevin, you mentioned the shift in merger objection lawsuit resolution towards these mootness fee type settlements, and obviously there's some interesting activity going on at the district court level and appellate level right now. Is there anything else you saw that was happening in 2019 that could be relevant for this type of litigation in 2020?
Yeah, you know, I have a number of sources that provide me listening to the filings as they come in, and I've noted that this has always been the case, but especially as 2019 progressed, increasingly a small number of plaintiffs' lawyers aren't filing these lawsuits as class actions. They're filing them as individual actions. And I think what's going on there is the likelihood of a federal district court getting directly involved in monitoring a voluntary dismissal of an individual lawsuit is even more remote than a federal district court judge getting involved in monitoring a voluntary dismissal of a class action lawsuit. So I think it's a move by the plaintiffs' lawyers to try and shift even further away from judicial scrutiny, which might make this even harder for courts to manage and create an even bigger problem for defendants involved in this type of litigation and their insurers. If we could shift to the first slide for the fourth section, please. You know, I've mentioned in these first three sections a number of significant trends that are causing problem for defendants in corporate and securities litigation and their insurers. And it really, I think, for any observer, it's no surprise that that has encouraged discussion in a number of quarters about the possibility of returning to securities class action litigation reform. Next slide, please. And among the significant initiatives is an effort by the U.S. Chamber of Commerce's Institute of Legal Reform, which hosted a conference earlier this year where several academics and practitioners spoke about, first of all, what's happening and what the trends are in litigation and what steps might be taken to provide some check on the clearly alarming trends in this sector. Among other discussions were topics under discussion were proposals for increased judicial supervision of securities suit settlements and increasing supervision of plaintiffs' fee awards. The D&O insurance industry has also been involved in these efforts. In particular, Chubb published a memo in summer 2019 from nuisance to menace which included a number of securities litigation proposals. Most significantly was a plea for Congress to revise the jurisdictional provisions of the 33 Act to address the Cyan problem in order to make sure that securities litigation remains in federal court and to eliminate the risk of parallel and overlapping litigation. Next slide, please. In addition to these suggestions for legislative effort, there have also been proposals for some self-help so that companies themselves might take steps to protect themselves against this type of litigation, particularly the possibility of parallel state court litigation. Numerous commentators, including in particular Professor Joseph Grunfest of Stanford Law School, have proposed that companies, particularly IPO companies, adopt federal forum provisions which specify federal courts as the exclusive forum for securities litigation. And post-Cyan, many IPO companies have adopted this litigation. There was a lawsuit in the Delaware Chancery Court where a shareholder of several IPO companies, including Blue Apron and Roku, sought to challenge the existence of the federal forum provision in the bylaws of those companies. And the Delaware Chancery Court ruled in December 2018 that, in fact, these federal forum provisions were invalid and ineffective. And that obviously throws a lot of cold water on the idea of these federal forum provisions as a way to try and combat the possibility of a parallel state court litigation. The case, which I believe is pronounced Shabakuchi, but it's also called Shabakuki, is on appeal to the Delaware Supreme Court. In fact, it was argued last week. And so stay tuned. I think we can look forward to seeing a decision sometime in 2020 on whether or not Delaware will permit Delaware corporations to have federal forum provisions in their bylaws. Any thoughts about that, Marissa?
Kevin, we've seen that at least Chubb and the COC have made comments about the issue of federal forum litigation or securities litigation reform. Are you aware that Congress is taking up this issue on how to address the Cyan problem?
You know, it's a great question, and I wish I could report to you that there was a specific initiative sitting on the table of some committee with optimistic that it might come out of committee to go to the chamber as a whole. Unfortunately, I'm not aware of any such initiatives, and my fear is that the current distracted and divided Congress, that the possibility of this common sense type of reform getting through, we all have to be somewhat less than optimistic, and that does mean, I think, that the self-help provisions might be the best model at this point for securities reform.
Understood. And as we hope, Congress will shift towards addressing this issue sometime in the near future. Do you think there's any way that the merger objection issue we're seeing could be addressed by securities litigation reform?
Well, again, it would take a more proactive Congress than I think we've got. But one possibility, and I think this might qualify as perhaps creative, but sort of a draconian measure would be that Congress could pass a statute that says there's no private right of action under Section 14, which is the statutory provision that private litigants are using for this merger objection litigation in federal court. I could see many different sides to whether or not that is or is not a desirable thing, and it might be viewed as sort of a powder keg solution. But I tell you, it would get rid of the federal court merger objection litigation. Plaintiffs' lawyers are creative; they might find another way around it. But that's one way it could be addressed. Again, I think we can all bring an appropriate amount of skepticism of whether this is the kind of thing that Congress might do. Kristen, can you go to the first slide for the Section 5? Thank you. I think those of you who, like me, find yourself talking to corporate directors and officers, you know that the topic they frequently want to talk about is cyber-related issues. And they're concerned about not only issues that would be of interest with respect to their cyber insurance, but more importantly, they were worried about their own potential liabilities and the possibilities of D&O claims being filed against them for their responsibilities for cyber-related issues. And observers have been predicting there would be D&O claims related to cyber issues. And over the years, there have been a number of claims, never quite in the volume that the observers expected, primarily because I think the securities marketplace has gotten used to companies announcing data breaches, and the marketplace is somewhat inured, and there typically is not a significant stop drop in response to this kind of news. There were two traditional securities class action lawsuits filed in 2019 against companies that data breaches, the most significant of which was the Capital One case. Capital One was by far the most significant data breach of 2019, with over 100 million U.S. customers having their personal information disclosed. And Zendesk also was hit with a securities class action lawsuit relating to data within its customer service database. The most important lawsuit on the next slide, really, though, is not those two, but the lawsuit that was filed against FedEx in June 2019. This one is of interest to me. It involved circumstances arising out of the exposure of FedEx's European operations, which it had acquired. It was the previously known organization of TNT, which in 2017, TNT was hit with the NotPetya virus, and it disrupted their operations. At the time, FedEx disclosed that the disruption would not impair its revenue, and most importantly, would not impair TNT's integration into the larger corporation. In 2019, the company disclosed that it was continuing to experience issues from the NotPetya attack, and it had disruption of its efforts to integrate the European operations. And upon that announcement, plaintiff shareholders filed a securities class action lawsuit. The reason this case is particularly interesting to me, because unlike the Capital One and Zendesk lawsuits and many of the other securities class action lawsuits, the FedEx lawsuit doesn't involve a data breach, and it doesn't involve the disclosure of private information. So it's a reminder that many different types of cyber-related incidents can cause D&O claims and securities-related lawsuits against D&O carriers. What are your questions about that one, Marissa?
So I understand that plaintiffs' lawyers, as you said, might not be so attracted to a securities claim where the data breach was not followed by a significant stock price drop. But in the alternative, do you think any plaintiffs' firms would try to file a shareholder derivative type lawsuit alleging perhaps breach of duty of care or other sort of fiduciary violations?
Not only do I think they might, they have in the past, and there have been, as I'm sure you recall, several very high-profile shareholder derivative lawsuits. Target, Home Depot, Wyndham Worldwide, all in the sort of 2015, 2016 timeframe, were hit with shareholder derivative lawsuits. So, clearly that is a path plaintiffs might pursue. They need to think about that, though. The lawsuits I just mentioned were not particularly successful. All were dismissed at the trial court level. And so, that track record is hardly encouraging. And that there are significant defenses to derivative lawsuits. There is the demand requirement. The defendants have the business judgment rule defense. So substantiating a derivative claim, they have to get over high hurdles, which may deter certain plaintiffs' lawyers. I think that possibility is always there, but there weren't significant data breach-related derivative lawsuits filed in 2019, and I think it's because of those hurdles. Doesn't mean we won't see them in the future. It's something the plaintiffs' lawyers do have to keep in mind. Can we turn to the first slide for Section 6, please? So privacy is a topic that's similar to and related to the cyber security topic I was just discussing, but it's also different. You can have privacy issues if there were to be a data breach, of course, but you don't have to have a data breach or other cybersecurity incident to have privacy problems. So as the next slide shows, there's a distinction between cybersecurity that I want everyone to keep in mind, and that's the distinction between cybersecurity, how data is secured, and privacy, how data is used. And if you turn to the next slide, there were significant developments in privacy in 2019. The most important of which was in the United States, the two significant privacy-related settlements that Facebook entered, first with the FTC and with the SEC. The FTC settlement was the whopping $5 billion penalty that Facebook agreed to pay, although I understand there's still some question whether or not this settlement will, in fact, be finalized by the FTC. Both of these regulatory fines related to the Cambridge Analytica incident, in which Cambridge Analytica had access to user data, Facebook user data. In addition to the Facebook settlements, there was the massive British Airways and Marriott International settlements, or rather penalties proposed by the UK Information Commissioner's Office, reflected here in dollar terms, both in excess of $100 million. Both significant regulatory settlements, both by the UK regulator under the GDPR. The Marriott International settlement is particularly interesting to me because it was a US-based company being targeted by a massive regulatory fine by an EU regulator. At least for now, the UK regulator is an EU regulator. Clearly, these significant regulatory settlements show that privacy is a high-profile issue. If you turn to the next slide, I think these and other developments have important implications for 2020. One of the most significant to watch is with respect to biometric data. The Illinois Biometric Information Privacy Act, or BIPA, during 2019 became the significant source of class action litigation in Illinois as a result of an Illinois Supreme Court decision, resulting in 161 BIPA class actions in Illinois alone through the middle of June 2019. Many listeners, I'm sure, have seen increasing numbers of quotes for in the healthcare sector and also in the EPL sector for BIPA restrictions or even BIPA exclusions. Not restricted just to Illinois, because many states have BIPA-related regulations. And so clearly a significant issue with respect to privacy in 2020. What are your thoughts about that, Marissa?
So it looks like we've seen some pretty impressive privacy-related fines and penalties being issued against these major companies. But my understanding is that those were not issued as a result of D&O claims. And how do you see these privacy issues becoming a D&O issue? And also, can you comment on the implication of fines and penalties as it pertains to the D&O coverage?
It's a great question, and it really is a little bit of trying to predict the future. But I think if there are to be D&O claims in the future arising out of privacy issues, there are at least two potential areas. One is just with respect to the potential liabilities of directors and officers of companies that are hit with those regulatory fines. If, for example, a company in the future were to be hit with, for example, a GDPR penalty, I could imagine a plaintiff shareholder filing either a mismanagement type claim or a disclosure type claim, alleging either that senior management did not appropriately manage the company or did not disclose to investors the risks that might come from the potential regulatory enforcement. Another possibility is a securities class action lawsuit around privacy disclosures. And there, I think it's significant that there was that $100 million settlement that Facebook reached with the SEC about Facebook's own privacy disclosures to its investors. And that, to me, is an example of how a securities class action lawsuit based on privacy-related disclosures might arise. I really think this is a significant area of future securities and other management litigation exposure. And I predict that in 2020 and in the future, we will see more of these types of claims, and this will be a significant area of D&O claims activity. If we could go to the first slide of the next section. So there has long been, on the next slide, there has long been a duty of oversight recognized in Delaware under the Delaware Chancery Court's Caremark decision. But for a long time, these cases have been viewed as difficult for plaintiffs to sustain, and the Delaware courts themselves have said that the pleading burden for plaintiffs in these cases is onerous. As reflected on the next slide, in 2019, significantly, there were two watershed decisions that allowed plaintiffs' duty of oversight claims to proceed. The most significant which is the first one, the Marchand versus Barnhill decision, in which the Delaware Supreme Court overturned the Chancery Court's dismissal of a Caremark claim that had been filed. Marchand versus Barnhill involved an ice cream company that had had a listeria breakout, and the allegation was that the board had not fulfilled its duty to oversee the significant food safety concerns, really a mission-critical concern for a food company. And the Supreme Court, in permitting the case against the ice cream company to go forward, said, among other things, there was no system of board compliance on an obviously central consumer safety and legal compliance issue. Well, the significance of that Marchand decision was seen in the October decision in Clovis Oncology, a Delaware Chancery Court decision where the Chancellor specifically cited Marchand and relied on it to allow a plaintiff's claim against Clovis to go forward, saying that there was a mission-critical regulatory issue where the board's oversight function must be more rigorously exercised. And I think everyone listening can, using some creativity, imagine mission-critical issues that really every company faces. One I particularly want to focus everyone on, if we can turn to the next slide, is the kind of cybersecurity and privacy issues we were just discussing. I'm sure everyone can imagine that for many kinds of companies, cybersecurity and privacy issues really are mission critical, and the kinds of enterprise critical consequences that the company could face if there were to be cybersecurity or privacy incidents, and about how the exposures might arise. It's important to know that the FTC settlement that Facebook entered included the requirement that that Facebook adopt specific board oversight mechanisms. I think the implication of Marchand is the boards are going to need to show good faith efforts to monitor critical areas of company risk, and one particular area is in that cybersecurity and privacy issue. So, any thoughts there, Marissa?
Kevin, do you know of any particular cases that are pending that you're looking out for to watch in 2020 with respect to this potential duty of oversight exposure?
One case I'm particularly interested in is the Delaware Chancery Court case that's pending against Boeing. I mean, I think everyone can appreciate that airline safety is absolutely mission critical for Boeing. And so it will be very interesting to see what the Chancery Court says in the Boeing case about the oversight duties of the Boeing board, particularly in light of the significant incidents that Boeing has experienced in the past 18 months. So that's clearly an important issue to watch. If we can turn to the first slide for Section 8, please. I quickly want to talk about environmental and climate change issues. Both of these are long-term of interest to me. You know, when we talk about these important emerging trends like cybersecurity and privacy, and even some that we're not talking about today, like Me Too, it's easy to forget there are these long-running concerns and that companies can face significant D&O claims based on their environmental disclosure. And there were two important cases in 2019 that were filed based on companies' environmental disclosures. The first was against 3M. Importantly, 3M entered a $850 million settlement with the Minnesota Attorney General based on its environmental practices. And the securities suit alleges that the company's misled with respect to one of the company's most important product offerings. It's product that's used in Gore-Tex. So the question was whether investors were misled about the regulatory and environmental exposures the companies faced. A second lawsuit was the Chemours company, which is a spin-out from DuPont. Interestingly, in the securities class action lawsuit, the plaintiffs in the securities lawsuit relied on allegations that Chemours itself specifically alleged in the lawsuit it filed against DuPont, saying that DuPont had under-reserved the liabilities of the spun-out unit. And then the securities lawsuit alleges that Chemours itself had not adequately apprised investors about the adequacy of its environmental reserves. So those two cases do show that environmental disclosures are a continuing exposure for companies with serious environmental liability exposures. The next slide relates to climate change. Different, but I think it's important that PG&E, the utility, or at least executives of PG&E, were sued in a lawsuit in 2019 based on the 2019 wildfires. They're related not only to the company's disclosures about its safety measures, but also the company's response to changing operating conditions arising from climate-related causes. PG&E, as well as Edison International, have been sued in the past on climate change-related disclosures. I think these both show the vulnerability of publicly traded companies to securities lawsuits based on the company's disclosures about how it's dealing with the changing operating conditions from changing climate circumstances. The viability of those kind of lawsuits, there is a question mark that will arise because of the outcome in the ExxonMobil climate change lawsuit. The judge in the state court lawsuit in New York held that the New York Attorney General had failed to sustain its burden to prove by preponderance of evidence that the company had been misleading in its disclosures to the investing public about how it was accounting for climate change. The fact that that lawsuit did not prevail really was just a question that the New York Attorney General did not sustain its burden of proof. So I don't know that it necessarily is one way or another a benchmark about the future viability of these kind of lawsuits, but certainly there are observers who are suggesting that possibility. If we can go to the first slide for section 9, I want to briefly mention shareholder derivative lawsuit settlement in 2019. In the past, there were significant cash components of shareholder derivative lawsuits. Usually the lawsuits settled for the adoption of corporate therapeutics and the payment of plaintiff's attorney's fees. But next slide, please. In 2019, there was a significant settlement in the Wells Fargo derivative litigation. I know most people on the call will recall the scandal surrounding Wells Fargo and its creation of bogus customer accounts. There were multiple shareholder derivative lawsuits filed against the board of Wells Fargo that were consolidated. And in February 2019, the parties reached a settlement of the consolidated litigation. And that settlement, the plaintiff's lawyers claimed a nominal value of $320 million, of which $240 million was cash. Of interest to the folks on this call, that cash component was the largest insurer-funded component of any shareholder derivative settlement anywhere in history. And the plaintiff's fees were $68 million. Next slide, please. So, in the past, shareholder derivative lawsuits were not did not involve a significant cash component, but increasingly there are significant settlements which represents a new kind of severity risk for D&O insurers. And the way we might think about that risk has to be taken into account of the fact of the plaintiff's lawyer's $68 million payday, clearly providing incentives. I think it's interesting to note that at the upcoming Plus D&O Symposium, there will be a panel led by my good friend Kim Melvin, in which they will be discussing whether the prevalence of a Side A insurance is in fact possibly contributing to this increasing prevalence of cash component contribution to shareholder derivative lawsuits. If we can turn to the Section 10, I think I've laid out a scenario that's pretty clear. There are a number of adverse trends that are coming together at once. They can only describe the current environment as alarming. And as reflected in the next slide, the current marketplace for D&O insurers and for their buyers is disrupted with increasing rates and increasing retentions. And we're seeing restriction of terms and conditions, and it's having particularly significant impact for IPO companies, as I mentioned before, but also healthcare, life sciences, technology, communications, financial services companies. And I think it's important to note that all these trends accelerated in 2019. And as far as I can see from where I sit, all these trends are going to continue into 2020. And that's certainly my perspective 2 weeks into the year. So what are your thoughts about that, Marissa?
So we went over a lot of information here, Kevin. And of course, our D&O underwriters have a lot to be concerned about with all this information. What do you think is the right message for our insurance advisors to be telling their clients about what to expect at the renewals in 2020?
Well, I think there are a number of messages. And I think, first of all, those of us who are advisors, we have to be proactive and we have to be out in front of this. And we have to make sure that we prepare the ground for the messages that might be coming later. I think what you want to do is, as much as possible, educate them about these changed circumstances of the kind that we've been talking about, so that buyers understand that whatever assumptions they may have built based on prior renewals, that those are no longer applicable to this renewal. And also that the marketplace is changing rapidly, which makes it hard for us as advisors to give them a clear picture, particularly for those IPO companies and companies in the other sectors that are disrupted. It's a moving target, which makes it very hard for us to give them an absolute window. We can give them a range of expected price increases and maybe a range of expected retention increases, but it's changing significantly enough that those may not be relevant by the time the terms are actually produced. So I think that's important, but I think it's also important here for the message to be communicated that in this environment, it's going to be important to communicate the significance of the changes, and that really requires expertise. And I feel that now more than ever, it's important for policyholders to enlist in their insurance acquisition process advisors with the requisite expertise now more than ever. I don't know if we have any time for any questions, Marissa. Do we have time for maybe one question?
Sure. So one thing we were chatting a little bit about, Kevin, before we got on to the podcast was with respect to the shareholder derivative matters is, do you think that the marketplace needs to view purchasing and providing Side A coverage differently now, given the derivative claim backdrop that we're seeing?
Well, it certainly validates the value of Side A insurance because of the rise of significant cash component. I think it certainly raises the question about what Side A limits are adequate, and we may need to think about that differently than we have in the past. It's not just a Side A issue. Obviously, traditional ABC cover has Side A coverage, and so it raises questions about the amount of traditional coverage that buyers may want to buy. It certainly raises implications for excess ABC and excess Side A insurers because these kinds of losses are pushing into layers they might not have in the past. I think with that, we're probably out of time, Marissa, so I'll turn it back over to you.
All right, thank you very much, Kevin. We appreciate all your comments and observations that you made this morning during this webinar. And I know some of our participants have been asking, and for those who are interested, today's webinar will be available on the RT ProExec website very shortly, and we will have a PDF copy of the webinar slides we had today available very soon as well. So look out for emails from us and our team in the coming days. And before we conclude, I want to let you guys know that Kevin and I are, again, very interested in your thoughts and reactions to this morning's webinar. So if you have a moment, please drop one of us a note to let us know what you thought of today's session. As you can see, our contact information is on the screen, email addresses and phone numbers. And again, we really thank all of you for your time this morning, and we wish everyone a very successful 2020, and we look forward to the opportunity to work with all of you. Thank you and goodbye.